Hello, CASA volunteers. Welcome. We are doing a training on permanency options. So we're going to review the permanency options that we have here in Delaware. And I want to make a note that this is a complicated topic. So just breathe, maybe take some notes as we walk through this. But I really want to dive into permanency options because that is why we are here. So I want CASA volunteers to remember that foster care is supposed to be safe, but temporary, okay? So when children come into state custody, we should immediately be planning for what is the permanency plan? What are we looking for the outcome to be? We want children to go to exit care into a safe and permanent place. It doesn't always have to be the home in which they came from, but we want them to exit care to a safe and permanent place. I want to challenge CASAs that it might not be a situation where you or I would particularly choose to live, but I want you to think about, is this what is best for this child and this family? All right, so without further ado, let's jump right into it. All right, let it just load here for a second. As we load, I want to encourage you to just be open-minded, and we're going to think about this. Let's try one more time. Sometimes my computer needs just a moment to think about it. All right, so let's chat. All right, so we've got a little bit of history because before we dive into anything, we want to know kind of where we came from. So there are three main pieces of federal legislation that really affect permanency. So the very first was Adoption and Safe Families Act of 1997. So this started to prevent or at least decrease the foster care drift. What does drift mean? So what used to happen prior to the mid-90s is that children would come into state custody at whatever age they would come in, and they would stay there until they were 18, regardless of how old they were when they came in. So if we remember a couple years ago, we read the book Finding Fish, which was about Antoine Fisher's experience in foster care. His story was in the 60s, and he came into state custody at 18 months old, and he aged out at 18 years old. So the idea with the Adoption and Safe Families Act was that it stopped a situation like that from ever happening. So it defined these permanent options and put specific timelines in place so that the child welfare system could achieve permanency. So you might hear your family court judges refer to the guidelines or the timeline. In essence, they are referring to this particular act. So it also made paramount that child safety and health was a paramount concern when it comes to reunification, which is one of our permanency plans that we will discuss today. There are certain situations that do not require reunification services to parents, and I'll chat about those here shortly as we dive deeper into our permanency options. And the court allowed court findings that were specifically required for 4E funding, which is specific federal funding that goes to support youth in foster care. For our purpose today, we're really going to talk about the time frame and the timeline. So parents have approximately 1 year to work on their case plan once we hit the adjudicatory hearing. So that's why we have the dispositional hearing that follows right after, which is about 30 days from the adjudicatory hearing. And then we have review hearings every 90 days. The reason we have those at specific times are so that we can follow the guidelines of the Adoption and Safe Families Act. Prior to 1997, there were no review cases. Nobody was double checking on anything that was being worked on. There were no case plans. There was no action being taken or, double checked to ensure that it was occurring prior to this act. So that's why judges are very cognizant of the particular timeline of when children have been in state custody. And that timeline starts at the adjudicatory hearing, which follows the preliminary protective hearing. So I'll dive into that for a second. An ex parte order is issued by a family court judge after the Division of Family Services. The attorney, the DAG, the Deputy Attorney General, files an ex parte petition explaining why they need emergency custody of a particular child. The judge will review it and determine whether or not there is probable cause to determine that there is dependency, neglect, or abuse in a particular case. Once a judge makes that determination, that's where the judge orders a court-appointed special advocate and a child attorney, legal representation for that child coming into state custody. Within 10 days, we have our preliminary protective hearing. 30 days after that, we have the adjudicatory hearing. 30 days after that, we have our dispositional hearing. And then every 90 days, we start to have those review hearings. We might have 2 to 4 or 5 review hearings, depending on the scheduling of everything. And then we have our permanency hearing. So the ASFA timeline put into place the guidelines in terms of when these particular court hearings need to be held. We also have our Fostering Connections to Success and Increasing Adoptions Act of 2008. This provided for funding and support services to allow youth to successfully age out of foster care up until the age of 21. In the last 2 years, it's been expanded to the age of 23. But prior to 2008, youth were aging out at 18, regardless of if they had graduated or not, and there was very little services provided to them in order to help them ease into adulthood. So this legislation provided for extended foster care and financial supports for them. It also increased efforts to find family members and fictive kin. It also provided incentives to increase stability. So the Division of Family Services has the ability to provide a youth with a board extension. What's a board extension? A board extension is that DFS agrees to continue to pay for room and board for a youth who is turning 18, but has not yet graduated high school. So what it does is it prevents youth from being homeless while trying to graduate. Most youth turn 18 their senior year of high school. We do not want youth to be homeless while they're trying to graduate. So it provides the ability for Division of Family Services to continue to pay room and board until a youth can graduate high school. Also required some transition planning at least 90 days prior to exit from foster care. In Delaware, we call that the STEPS meeting. It's a transitional meeting where we write down the plan that this youth has upon exiting foster care. This law also addressed some sibling visitation and placement options, really encouraging the system to place siblings together if at all possible. And it also provided some incentives for adoption, especially for youth of special needs and older youth. Money. I want you to think about money when it comes to this particular act because it put money behind some ideas and some actions. Finally, we have the Preventing Sex Trafficking and Strengthening Families Act of 2014. Really what this did for us was it prevented any permanency plan other than APLA for youth under 16. So only 16 and 17-year-olds can have APLA as a permanency plan. APLA is another planned permanent living arrangement. It is fancy for long-term foster care. So prior to 2014, we saw, a very high number of youth, roughly ages 11 to 15, whose plan was APLA, which just means long-term foster care. So if you have an 11-year-old with APLA as a plan, that means we're sentencing that youth to 7 more years in foster care. So what this act did is it really created the necessity for the child welfare system to work hard and be creative at finding permanency options, which leads us into our permanency options. All right, so what are our permanency options? I'm going to focus mostly on these 4. We have reunification, adoption, permanent guardianship, and guardianship. I will briefly touch on APLA, but for the most part, I really, really want to encourage CASA volunteers to think about these 4 options. So more often than not, reunification is our primary plan, especially when a youth comes into state custody. On average, in the last few years, we have reunified just shy of 50% of the time. It's been in the 40s percentage-wise. And we know, based on several studies, that youth do better in life when raised by family. Most of your youth will, when asked what they want to have happen, will admit that they want to live with their parents. Families are bonded together, and our goal is not to rip them apart. We want to try to keep families together. So we will initially reunify with mother and or father, or potentially another relative if the youth was living with, maybe potentially under a guardianship with another adult who is not their biological parent. We have adoption, which is adoption by foster family or a relative, but the family needs to be identified and approved by the Division of Family Services to be an adoptive resource. CASA volunteers can play a very important role in choosing the adoptive resource family, and should be included during that process. Permanent guardianship is by a relative or a previous guardian, and it can be by a foster family as long as the child is 12 years or older. The idea with permanent guardianship is that we really want to keep a youth with their family, even if it's not a biological parent. And then guardianship can be filed by any person that just has a connection to a child. So let's dive into these options in a little more detail. So reunification is our primary plan in most cases. Parents must comply with their DFS case plan, and the court will determine that the child is safe in the care of their parents. That's when reunification can happen. So we work with Division of Family Services to create case plans that are best made for particular parents. So on a case plan, we might have a substance abuse evaluation and seek treatment. Participate in a mental health evaluation and seek treatment, attend domestic violence counseling and support services, attend visitation with the youth, attend parenting classes and or work with a family interventionist, attend all school and medical meetings and checkups for the youth. They might have to comply with any criminal requirements such as probation or parole. They must have appropriate housing, safe and appropriate housing, as well as income, whether it's through employment or another source. They must be able to financially support their child or children. So those are the things that are on a case plan. So in the beginning of a case, usually by the dispositional hearing, parents are given their case plan. By the time we leave that dispositional hearing, there should be no questions about what the parent needs to do. It should be laid out to everyone. The judge will help organize that and make sure that once the dispositional hearing is over, everybody knows what is expected. And then it is Division of Family Services responsibility and task to provide reasonable efforts towards reunification. So the Division of Family Services worker is going to be the one to make referrals to these different services and counseling services. They're going to be the ones that might set up visitation. They might collaborate with other state agencies or organizations to provide assistance to the families. As a CASA, you can collaborate with that DFS worker to try to perhaps make some suggestions on what resources might be beneficial, as well as just stay in touch with that DFS worker to understand what the case plan is and what actions the parents are taking on their case plan. DFS is not the only person that can provide that information. I strongly suggest if there's a family interventionist, the CASA should work with that person to learn about how and when visits are happening. They can also work directly with the biological parents and family. We want to be a support system to this family. And while reunification is the permanency plan, we're going to all work on that. So I want you to think reunification until it's not. So there is a limited time for case planning, and that refers back to our Adoption and Safe Families Act, where those timelines come into place, where a parent has 1 year to complete their case plan once it hits the adjudicatory hearing. There are often times where a judge will allow a little bit more time to complete a case plan, especially if a parent is making progress and just needs a little bit more time to secure a particular element on their case plan. Perhaps they need to continue substance abuse treatment and prove sobriety a little bit longer. Perhaps they need to obtain an appropriate house. Maybe there's just one or two things outlined, sort of left on that case plan. A judge will provide most of the time a little more time to work on their case as long as they're making some progress. So we talked about reasons why we would not reunify. There are a handful. So an example might be that a parent is incarcerated for a lengthy period of time. So for example, the Adoptions and Safe Families Act provides 1 year time frame. If the parent is incarcerated for a minimum, their good time is over a year, there's a chance we might not reunify with that parent since they're incarcerated longer than that time frame. Another might be if a parent is deceased. Another could be that the parent is unknown. Another could be that the parent has decided they are not interested in reunification. For whatever reason that might be, we might not reunify. And kind of a final reason is if a parent is believed to be or proven to be the perpetrator of violence against the child. Those might be some reasons why we would not work on reunification. So it's a reunification example. We've got, the vast majority of our cases end in reunification. So this would just simply be a case where one or both parents have successfully completed their case plan. They've gone through the trial reunification process, and the judge has rescinded custody back to the parents. So what might a trial reunification look like? Oftentimes, parents are provided weekly visitation with their child or children, and perhaps they see them, they have twice a week visits for 2 hours. Once we get towards that trial reunification stage, we want to set the family up for success. So let's assume that there's been several months between when the child came into care and when we're ready for reunification. Rather than put the child back in the home and disrupt any stability and skills that the parent and or child has learned, we want to make this a smooth process. So an example might be that we go, the first 2 weeks, we go to a day visit, meaning the parent has the child unsupervised from 10 a.m. to say 6 p.m. or 4 p.m. They have them for the bulk of one weekend day. They'll do that for about 2 weeks. Then they might go to one overnight. So they will receive their child on Saturday morning and then return them back to the foster home on Sunday afternoon. We'll do that for another 2 weeks. Perhaps the third set of weeks goes 48 hours. So they get them Friday afternoon and return them Sunday afternoon. That goes for another 2 weeks. And then finally, we'll get to trial reunification where the child is in the home full-time, but Division of Family Services maintains custody and all support systems are still in place in case the parent needs them. Once Division of Family Services and perhaps CASA and perhaps parents feel that reunification is imminent, it's time, then we will have a hearing with the judge to rescind custody back to parents. We have lots of positive examples about these. So those are just kind of a general idea. Talk about adoption. All right, so adoption, in order to do so, the court must terminate parental rights. So this is the legal severing of legal rights between parent and child. And it must be proven by clear and convincing evidence that DFS has at least one of these grounds listed below, which we'll review in a moment, and it's in the child's best interest for termination of parental rights to be granted. So I want you to think that parental rights are only ever terminated for purposes of adoption. The system would not terminate parental rights just because as soon as we do that, the sole guardian of that child is the state. The state should not be a parent. So, that child is in essence an orphan. We don't want that to happen. So we terminate parental rights with the focus on adoption. But we can't just terminate anybody's rights, okay? So let's look at some of these grounds to terminate parental rights. There must be at least one of these present. So abandonment means the DFS or the CASA, have not heard from the parent in about 6 months. That can be deemed abandonment. They are not participating and they are not engaging in any services of any kind for a period of about 6 months. Next would be failure to plan. The parent has failed to complete their case plan. So it could be one element, it could be all the elements. There's something that is not completed on their case plan. Another could be voluntary consent, which means that a parent voluntarily agrees to terminate their own parental rights. Fourth would be prior involuntary termination of parental rights for another child. So bear with me here for a second. If a parent has a child and it ends up in the termination of parental rights stage, and the parent fights for their rights and loses, and the court terminates their parental rights, that is deemed an involuntary termination of parental rights. If that happens and their child is adopted, any future child that parent has, the Division of Family Services does not have to case plan with them. They certainly can, but they don't have to. So that alone can be a ground to terminate the parental rights of any future child. This also applies to any other state where an involuntary termination of parental rights occurred in another state. Delaware acknowledges that, and that also counts. So you might see, if your case comes to this, the parent attorney to a parent might strongly advise their client to consent to terminate parental rights because it protects any future child they may have that might come into Division of Family Services care. So that might be a reason why a parent attorney would advise their client to consent as opposed to go down the termination of parental rights road and potentially have an involuntary termination of parental rights. Another could be mental incompetence of the parent, which simply means that there are no amount of services that can be provided to this family to allow the parent to safely parent. So sometimes that can be its own ground. Also, the parent might have committed a felony against the child. That can be a ground. Or the parent subjected the child to torture, chronic abuse, sexual abuse, or life-threatening abuse. That also usually involves the criminal side of child welfare, of the justice system, but the parent was the perpetrator. Could also be that the child suffered serious, unexplained physical injuries. We call that sometimes failure to protect. We don't necessarily need to know who caused the injuries to this child, but if it's apparent that a parent was there and failed to protect the child, that might also be a ground. So these are all reasons to terminate parental rights, and it must be proven by clear and convincing evidence, which means the judge has no doubt that the parent abandoned the child, that the parent failed to complete their case plan, that a parent voluntarily consented. So that is a pretty high burden to prove. So once we get to termination of parental rights, the Division of Family Services has a pretty strong case against the parent of why the child is dependent or neglected in their care and why termination of parental rights is in the child's best interest so that they can be adopted. What happens for adoption criteria? So this is the best interest factors for Delaware. And these are actually taken into account, not just for adoption, but also the other permanency options. But part of our role as CASA is to examine these best interest factors. So we want to take a look. What are the wishes of the child's parents or parent? Sometimes we're reunifying with one parent, sometimes we are reunifying with two. So we also want to identify the wishes of the child. So regardless of the child's age, we usually suggest verbally, they can speak, so they're 3-ish, 2-ish and above. The judge will put different weight on the child's wishes. So for example, a youth who might be a teenager would, their desire, their wishes might weigh more heavily on a permanency option than a younger youth, knowing that as the older youth nears adulthood, where are they likely to go anyway? So we try to take into account their wishes based kind of on their age. We also want to identify the interaction and interrelationship of the child with the residents of the household where the child lives. So we now know that there are lots of families that live together in a home. And when I say family, I mean multi-generational. We might have 3 or even 4 generations living under the same roof. What is the youth's relationship with any one of those other adults? Also think blended families, step parents, step siblings, paramours of their parents. So think about their relationships with others. Also, the child's adjustment to their home, school, and community, as well as the mental and physical health of all people involved. We also want to look at the parents' past and present compliance with the rights and responsibilities of their child. Have they been involved with Division of Family Services in the past? If so, how did they do? Did they reunify with their family? Did DFS even take custody of their child? Remember, sometimes Division of Family Services gets involved to assist a family, but does not need to take custody. Maybe they just are able to provide services or resources to a family, and the family is able to utilize those resources. So those might be very helpful as well. We want to take a look at if there's any history. How has the family reacted in the past? Is there any evidence of domestic violence evident? And what is the criminal history of all parties or residents involved? So when it comes to adoption, the adoptive resource family, which is the adopting family, will undergo criminal history to ensure that no one in that home has any concerning criminal histories. So we want to take a look at these best interest factors and keep an eye on what is in the best interest of this particular child. All right, so let's chat about legal requirements for adoption. So in order for someone to adopt a child, the parental rights are legally terminated and the appeal process has been exhausted. So once a termination of parental rights ruling has been made by a family court judge, the biological parents have 30 days to appeal that decision. What that does is that involves bumping it up to the Supreme Court of Delaware, and is usually roughly a 6-month process, give or take. So the parental rights must be legally terminated and the appeal process is exhausted. There's a home study completed and approved by the Division of Family Services Permanency Planning Committee, which means they've completed their home study and the adoptive family has become the chosen adoptive family for this particular child. The child or children must reside with the adoptive parents or adoptive family for a minimum of 6 months while being supervised by a licensed agency here in Delaware. And if the child is 14 or over, they must consent to their adoption, which means they are very much a part of this process. And with adoption, there do come some benefits. So adoption is permanent. That child is legally the child of the adoptive parents. The biological family cannot file any paperwork in family court to rescind, which means take back custody. That child is legally the child of the adoptive family. However, contact with the birth family is at the discretion of the adoptive family. When the adoptive family is going through their adoption classes, they learn how to honor the birth family. And they learn how to explain to the child about adoption and what their birth story is. So the adoptive family is able to make decisions about contact with the birth family, but an adoptive family might choose to keep photos, maybe have an email address where they email photos to the biological family. Maybe they stay in touch with the biological parents. It's totally up to them, but it is up to their discretion. The child is automatically provided with Medicaid, so they have their medical coverage provided. And the child may be eligible for a financial subsidy until the age of 18. So that was part of the Adoptions Act of 2008, was that it provided some adoption financial benefits for any youth adopted out of foster care. Now, how much is it? Totally depends on the child. It is roughly the same amount that the foster family was receiving in supporting the child. So there are levels of care, which is a whole nother training that I won't get into right this moment. But there are levels of care, 1 to 5, 5 being the highest, 1 being the lowest. For example, teenagers by nature are roughly a 3 because teenagers require more money. They eat more, they use more electricity, they use more hygiene products, they cost more to feed and house. So they're a 3 kind of by nature of their age. We might have a healthy infant, with no significant needs. That might be a 1. We have a nonverbal autistic youth, that might be a 5, for example. So those levels of care is what determines the reimbursement for foster parents, whoever's providing care for this youth. We do have a separate video recording training on levels of care, and I believe we also have a podcast on it. So if you have more questions about levels of care, that's a good place to go. But the subsidy is generally based off that level of care. Rarely, I won't say never, but I can't think of any situation where the subsidy would be more than what the caretaker was receiving while the child was in DFS custody. The idea behind this is that the money follows the child in order to support the child and their needs. If a child is 16 or older during an adoption, they are still eligible for independent living services up until the age of 23. So those independent living services start at age 16. We have several recordings and podcasts based on independent living services. So if you have additional questions on independent living services, head on over to check out one of those. But independent living services start at age 16, and they help a youth plan for housing, employment, education, mental health supports and coverage, and financial assistance. So an independent living worker will work with a youth to help them with their independent living skills. And that starts at 16, and they can receive their benefits up to the age of 23. All adoptive families are eligible for free post-adoption services. We'll chat about those in just a moment. The idea with supporting adoptive families. Many families struggle as life goes on. So perhaps they adopt a youth at age 1. Maybe when that youth hits 11 or 10, 11, 12, they start to have some questions, and they might have really struggle with the adoption experience. So the post-adopt services are aiming at helping the adoptive youth as well as the adoptive parents and family. So an adoption example could be that a youth comes into care. It's certainly possible to have a teenage adoption. We certainly have had them, and we want them to happen. We don't ever want to not have somebody adopted because of their age. Obviously, if they have to be under 18, but that should never be a hindrance. So an adoption example could be that the biological parents failed to complete their case plan, or failed to, maybe they consented, or maybe they abandoned the youth. They stopped becoming involved. That would be an example where we would have an adoption where the legal rights of the biological parents are severed or terminated, and the adoptive family is now the legal family of this child. All right, here's some post-adopt services. So they also do crisis intervention. So if a youth is really, really struggling, post-adopt services are provided by ABCFOC for another acronym, which is A Better Chance for Our Children. They provide crisis management and intervention. They also provide what's called rec and respite, which means recreation and respite. So on a Saturday from roughly 9 to 4 or so, adopted youth get together and play games and interact with one another, and really engage in supportive peer services, while the parents and family can go run errands, take some respite time, and go do something else. So it provides a little bit of mental health supports with some kind of time off. Post-adopt services also include continuing education and training and support to families, especially as a youth ages and starts to have some questions about their adoption. They also provide parent-child bonding workshops to help this adoptive youth engage with the adoptive family and become a family. All right, now we're going to get to permanent guardianship. So in order to petition for permanent guardian, the petitioner must be a relative, a guardian, meaning they already have guardianship, or a foster parent, as long as the child is 12 years or older. There are some limited exceptions, especially if there's a sibling who's 12 or older, but a younger sibling might not be. They will go with the older sibling. So the petitioner must be related or connected to this youth somehow. The state statute we're recording this just before it happens. At the end of January of 2024, the legal language changed a little bit to expand who a relative is. It now includes some additional connections, including step parents, ex-step parents, things along those lines. The proposed permanent guardian must prove the best interest. So we went through those 8 best interest factors, and that termination for parental rights grounds exist. So I want you to think of permanent guardianship is everything TPR adoption is minus the TPR, okay? So if the petitioner is a foster parent or guardian, then the child must have resided with the petitioner for at least 6 months, just like with adoption. If the child's 14 or older, they must consent. And a social report known as a home study and adoption classes must be completed by the permanent guardian. So we've had some CASAs ask, how long does this process take, becoming a permanent guardian? And it really depends on the availability of resources and the action of others. So it could take 3 to 6 months. That's just a ballpark. We know that the youth, or it could take more than 6 months. We know that the youth has to be in the home for at least 6 months. While the youth is placed there, it is possible to also be getting the home study done and the adoption classes completed. So it's possible to kind of do all these things at one time. Sometimes permanent guardians take a little longer to complete their home study than others. Just depends on how quickly information is turned in and processed. There are some benefits to a permanent guardian is that birth parents cannot march into family court and apply to rescind the guardianship. The only rescind means give back. The only way that permanent guardianship can be ended is if the permanent guardian decides that it is time and that the child is no longer dependent or neglected in the bio parent's home. Usually Division of Family Services will get back involved. They may not take custody, and that's fine, but usually they will check out the biological parents and see if they've made progress on what was their previous case plan. Parents are permitted visitation per court order or agreement. Again, it's kind of up to the permanent guardian to kind of set some parameters, though the court can get involved as well. The guardian can apply for child support from the biological parents. Doesn't mean they'll get it, but they can certainly apply for it. Based on the guardian's financial situation, they can apply for financial assistance. This is all through Department of Health and Social Services. So they might be able to apply for TANF, which is Temporary Assistance to Needy Families, might be purchase of care, known as POC, might be Medicaid, which is medical coverage, or food stamps. All of this is dependent on the guardian's income, which might be thrown off by the child's eligibility for a financial subsidy. So this is the same subsidy that would be received under an adoption order. My experience has been that if a guardian receives the adoption subsidy, they do not financially qualify for the other social services. So I want you to remember that TANF, purchase of care, Medicaid, and food stamps is all income eligibility. Once the family starts receiving a subsidy, it might bump their income too high in order to receive those other services. So you get one or the other, but not both. All permanent guardians are eligible for the free post-adopt services that we just went through for adoption, adoptive families. And if the youth is 16 or older when guardianship is granted, then they are still eligible for independent living services up until the age of 23. So they are still eligible to receive those. What I like about permanent guardianship is that it really puts a lot of ownership and protection on the permanent guardian. Sometimes permanent guardians and biological parents do not have the best of relationships. So I feel that a permanent guardian is much more protected from the biological parents if they have that concern of the biological parent filing petitions in court in order to have their child back. You might be asking, why would we do permanent guardianship instead of TPR adoption or something else? So I had a situation a number of years ago where we had a family member of a biological parent serve as a kinship care provider, sort of a foster parent specifically for the baby that came into state custody. So it was the baby's mom's cousin, first cousin, who was providing care for her. We tried to reunify with mom for about that year-long time frame. That entire time, the baby was with the maternal cousin, and the cousin and the biological mom, both of their moms were sisters. And the cousin reported some family rift between one side and the other. And she absolutely wanted to care for this baby for the rest of this baby's life, but did not feel right terminating the parental rights of her own cousin. So this was a situation that was perfect for permanent guardianship. The caretaker is biologically related to our baby, and it was not in the best interest to terminate the parental rights of the baby because the mom was involved, but we could certainly have argued that it wasn't enough and that there was grounds to terminate parental rights. But in maintaining a permanent guardianship permanency plan, biological mom was able to keep her parental rights, and we were able to prevent a pretty significant family feud, also while providing care and support to the cousin, the family member who was raising the baby. So that would be an example of permanent guardianship. Then we get to regular guardianship. It's not called temporary guardianship, it's just guardianship. So it is any person can file for petition of guardianship. There just needs to be some paperwork that needs to be filled out. But the burden on the potential guardian is to prove that the parents are unfit, meaning the child is dependent or neglected in the parent's care, and that guardianship is in the child's best interest. However, there is no protection for that guardian. So a guardianship could be granted today, and tomorrow, for example, the birth parents walk into family court and file to rescind custody. They want their custody back. Once guardianship is granted, Division of Family Services goes away, CASA goes away, all support systems go away generally. So the guardian is really left with pretty limited resources. So we would suggest, a guardianship in a situation where the guardian and the biological parents have at least some working relationship. That might just be an example. There's also no age restriction for the child, but if the child is 14 years or older, they do need to consent to it. They need to agree to it. And guardianship must be found by the court to be the most appropriate permanency for this child, meaning that permanent guardianship doesn't work for a particular reason, and termination of parental rights doesn't work, and reunification is not happening. There are some benefits to guardianship. Just like with permanent guardianship, the guardian may apply for financial assistance through Department of Health and Social Services. Again, these are dependent on income. So if the guardian receives too much funds or through employment, or their income is too high, they will not be eligible for these services. The guardian may apply for child support from biological parents. Doesn't mean that they will get it, but they can certainly apply for it. Parents are permitted visitation through court order or agreement, and if guardianship is granted when the child is 16 or older, they are eligible for independent living services, again, up until the age of 23. So I want you to think about terms of severity when it comes to strength of permanency. So termination of parental rights for purposes of adoption is very, very strong in terms of who has the ability to make decisions for children. When that happens, it is the adoptive family. So there's no way the biological family can come back and ask to have the child back. Permanent guardianship is like a little bit less strong. I don't really know the right word to say. Strong and strength doesn't really seem right, but I don't know what other word to use. Where permanent guardianship is in place, the permanent guardian still can make all the decisions, but the parental rights are still intact. And then with guardianship, it's just a guardian making decisions, but biological parents' rights are still intact, and they're able to make some decisions. So a guardianship example might be that we have a 17-year-old who cannot reunify, does not want to be adopted, does not want to go to a permanent guardianship, but is perfectly happy going into the guardianship with grandma, or grandpa. And usually an older youth who can express their needs. Are they being hurt? Are they hungry? They can communicate and protect themselves, where a younger youth might not be able to do so. So we see a lot of guardianships with extended relatives, and we just prove that that's in that child's best interest. So then we have another planned permanent living arrangement. So I want to really stress that this is a status, not a permanency plan. It's not permanent. It is a good idea for some, but I'll focus on that in a second. And it must be proven to the court that reunification, adoption, or either of the guardianship options are not possible or appropriate. So with the Permanency Planning Committee through DFS, it is possible to have a concurrent plan, which means we have more than one permanency plan happening at a time. We could have reunification and TPR adoption. We could have guardianship and permanent guardianship. We could have all four of those all together. What we cannot concurrently plan with is APLA, because by definition, APLA means that none of these other four options are possible or appropriate. So the court must find that there are compelling reasons that APLA is in the child's best interest and that no other permanency plan is appropriate. There are some benefits in that Division of Family Services will continue to pay their monthly board payments until that child ages out or graduates high school. Again, we want high school graduates. We don't want youth homeless when they're trying to graduate, usually their senior year of high school. If there is special education involved, the youth is able to receive services to age of 21 or when they graduate with their diploma. DFS does remain involved. And then visitation with the birth family is per DFS or court order if the family is around and active. Court review hearings are held on a regular basis, sometimes 3, sometimes 6 months at a time. And the independent living worker is assigned to the youth at age 16, again, to start working on the youth's plan for employment, education, housing, mental health services, and financial services. Youth 18 or older may apply for a board extension or other funds in order to, continue, which we just chatted about, that those monthly board payments are paid out by Division of Family Services so that the youth can continue to stay, hopefully where they're already living, if that's a good living arrangement, or support them in a living arrangement that might be something different. So I had an example of an APLA case where we had a 16-year-old young man who did not want to be adopted. He could not reunify with biological parents, and there was no potential guardian or permanent guardian. However, he lived very happily in his foster home, and the foster parents were dedicated foster parents, but did not have any desire to take further permanency action on any of the youth that they were fostering. They'd been wonderful foster parents for a better part of 2 decades and were totally happy doing what they were doing. And they made it very clear that our youth could stay there indefinitely. They just did not want to take any other action other than, staying his foster parents. They liked the support of having Division of Family Services, and they liked having the CASA. They were not interested in any type of permanency plan. But again, he was welcome to stay there as long as possible. That's where he wanted to stay. He wanted to stay with them. He did not care what permanency plan was written on paper. He knew he felt at home with that family, and that was fine. So we did APLA for him, and he ended up graduating, aging out, and joining the military. So that would be an example where APLA might be a good possibility and good example. But what can CASA volunteers do to assist with permanency? So number one is always consult those best interest factors. Those are the 8 elements that look at the parent's wishes, the child's wishes, the child's adjustment to home, school, and community. So go through those 8 best interest factors on a regular basis. We also want CASA volunteers to attend all meetings associated with permanency. This means the Permanency Planning Committee meeting, adoption selections if there's more than one adoptive family, and also work with the youth to seek out additional family members or potential supportive adults. Oftentimes, the youth can be the key to finding their own permanency option. Now, I certainly understand that some youth propose options that are not safe or appropriate, but when working with a youth, CASAs can at least start with identifying as many potential resources as possible, and then we can work through the logistics of which ones work and which ones may not work. A challenge to CASAs is in the beginning of a case, Division of Family Services will have done some reaching out to family members and friends to identify if anybody can step forward to take permanency of a youth in the very beginning. There might be buried in that ex parte petition from Division of Family Services a list of potential resources. As a CASA, I encourage you to go back through that ex parte on a regular basis and revisit those people. We can also engage in some family search and engagement activities, which means talking to your youth about who they feel supported by. I always like using a youth's cell phone if they have one. Go through their cell phone and who were the last 10 people that they called, texted, messaged, social media contacted. Who were they in touch with, and are those people potential resources for the youth? Don't be afraid to ask, because we never know. We can also work with biological family to identify if there's any additional resources or anybody out there who might be available for permanency for this youth. We want to involve the youth in permanency discussions, especially if they are older youth. We want to really support the youth to advocate for themselves. Okay, we're building a life skill. What are their needs? What are their wants? What are their desires? Talk to them openly and often about what they want to see happen. And then CASA volunteers remain on the case until permanent living arrangement is secured. So CASA volunteers come in with a court order from a family court judge, and we will more or less go out with one, whether it's a reunification case, permanent TPR, adoption, the child is adopted, permanent guardianship, or aging out at either 18 or 21 if a CASA volunteer stays involved with extended jurisdiction. Again, we have several trainings on extended jurisdiction, but in short, extended jurisdiction means that the court and the CASA volunteer may stay involved in the case until the child, now a young adult, turns 21. So it allows that CASA to be involved from the age of 18 to 21 as the youth is aging into adulthood. I've had several CASAs ask questions about all right, so we're going to chat about this. So I've had several CASAs ask questions about permanency versus placement. Now, these are two very different things. Placement is simply where the child is living, who is providing daily care for a child. You might hear the term non-relative resource parent. That is another name for foster parent. The system is trying to get away from the F word, the foster youth, foster parent, foster system, because it carries with it a negative connotation. So by using the term non-relative resource parent or just resource parent, has a little more positive vibe to it, and takes away that stigma, I'll say, about a foster youth. So if you ever hear that word, that's what it is. It's a different word for foster parent. Resource parent is just somebody that's providing resources to that youth. It's who's providing care for them. But that does not necessarily mean that they are a permanency option. Hopefully, we can at least have conversations with that resource family to determine whether or not they are a potential permanency option. So I want you to think about resource as a family that cares for a youth in state custody versus permanency, somebody is ready and willing to take legal action. So when we talk about permanency, we really are talking about those legal actions. Termination of parental rights for purposes of adoption, filing for permanent guardianship, filing for guardianship. So that's what we want to think about, is permanency equals legal action. We also have relational permanency. So kind of a little side tangent here on relational permanency. Relational permanency means that it is somebody connected to the youth who is not necessarily providing daily care for them. They are not necessarily a resource parent. So perhaps a relational permanency person would be a teacher, an adult sibling. It could be a biological parent. It could be a biological family member. It is somebody who is connected to the child that cannot or will not provide legal permanency, meaning they're not going to reunify, they're not going to adopt, they're not going to take permanent guardianship or guardianship of a youth, but they're still very much connected to that youth. We want to really support those relationships and really support a youth having someone. We know that all it takes is one steady, consistent adult in any youth's life to make a huge difference. Sometimes that person is the CASA volunteer. but sometimes it's additional people or other people. So if there is relational permanency, it's somebody that the child is connected to, that person is providing support, usually emotional support to that youth while they go through the system. That concludes our discussion about permanency options. If you have any questions, your greatest resources can be your triad team. So I really encourage you to chat with your CASA coordinator and your child attorney about permanency options for your case. Sometimes we feel like we're backed into a corner. We don't really have many permanency options, but let's get creative. Let's really try to challenge the system. Let's try not to depend on others. So we're not going to wait around for DFS to contact us. Let's take some proactive actions in identifying some potential resources. Then we can work with Division of Family Services to determine if that person is safe and appropriate. You may disagree with DFS, and that's okay. Remember, we're not here to agree. We're here to speak for that child, but we're also not here to fight DFS. So we are partners, we're teammates, we're playing the same game. We're just playing different positions. So be very respectful with DFS, be patient, but be persistent as well. Their role is to provide services to the youth in state custody. And that's a big task. That's a lot, especially this day and age when there's simply not enough workers for the work involved. So be patient, be kind, but please be persistent. If you hit any roadblocks, that's what your CASA coordinator is for. They are your supports. If you have an idea, as wild as it may seem, talk to your CASA coordinator about it. We've had some CASAs come up with some really creative permanency options, or at least some relational permanency solutions. So be creative. One of the best things about being a CASA is that we are not super bound by a teeny tiny little box. We can be creative. And your advocacy comes in such a variety of ways that you can really have an incredible impact on a youth that you are working with. If you have any questions, please contact me directly. I'm happy to chat with you specifically about a case. You feel free to send me that email and we will work it out. So thank you so much for listening and watching today's recorded video about permanency options. I hope you found it helpful.